For those of you guys also checking out the webinar, we have a full 41-page webinar here put on by somebody I actually work with, Ethan, one of my lawyers. And he's pretty familiar with our group. What did you come to our retreat? Not last year, but in 2021, you got to meet our group, and apologize I put you on after lunch. That was rough. And because what we're going to be going over today is not just like the basic stuff, like LLCs and probate, boring stuff, but we're going to try and get through that in the beginning, of course, in 2 minutes, but then really get into the good stuff on what do high net worth people do to protect their assets with a little bit more exotic strategies, stuff that Ethan has helped me out with myself. This is, of course, infotainment here. Ethan works with a lot of Hawaii clients because he is here in Hawaii. It may not work if you're in California, but the idea here is watch this webinar and listen to the topics that we're talking about, because then you can possibly talk to your estate attorney and bring in these types of aspects, and as opposed to you just getting a cookie cutter one out there on the internet. But yeah, thanks for jumping on, Ethan.
Yeah, you bet. It's a pleasure to be here as always.
Yeah, thanks for putting together these slides. Let's start off with probate. But I have a will, right? Isn't that okay?
Yeah, so a lot of people ask me the question, if I have my will, I don't have to worry about probate. And that's completely wrong. Actually, probate is the process of proving that your will is valid. And what's wrong with that? The probate proceeding is going to court and gets the judge involved. We notify all potential beneficiaries and creditors. And the biggest problem with it is that probate is public record. So anybody who wants can look up your estate to see what you owned, who got what. And most of my clients prefer the privacy of a trust over using a will to go through probate.
Yeah, it basically spills all your stuff out there. What was that? Chadwick Boseman, the Black Panther. We know his net worth. We knew where everything was at.
Yeah.
It's sad. And it's costly too, right?
Yeah. Whenever you get lawyers involved, things get costly. And if they have to go to court, it gets more costly. Yeah.
Another lawyer told me one time that lawyers who do wills for people, it's a little bit unethical because it's now they know that go back to you to do the probate work and you get paid for that. Like, why do people even do wills if it causes so much trouble and you just do it a trust?
Yeah. Don't get me wrong. A will is better than nothing. If you have nothing, then whatever rules in your state about who inherits in the absence of a will take over. So it might be people you don't want to inherit from you, whether it's a second or third spouse or kids from a prior marriage or whoever is entitled to whatever you get, a kid you didn't even know you had. So without a will, there are default rules that you're stuck with. So it's good to have something in place. But to your specific question about having a will versus a trust, I think you're right. There are lawyers who will specifically set up the will so that you get the client to come back to you or their kids or family members to do the probate, and they get paid on that. In some places, it's a percentage of the estate. And if you have a few $1 million estate, it could be a very large payday for the attorney and their team. And I've even seen lawyers who write into the will that the family has to come back to that law firm to do the probate, which is not enforceable, but it's enough to scare the kids or spouses of the deceased.
Yeah, sneaky. It's like those property managers that write into the agreement that you have to use them as your real estate transaction person. When you finally realize that accredited investors want to get away of rental properties as much as possible because of the pain in the ass and the high liability. But anyway.
Yeah, just like that.
Just like that. So you want to trust, right? Maybe it's the cost. Wills cost a fraction of a trust, right? So is it just people are being cheap then?
Yeah. And depending on how complicated you want to make your will, it could be more than the trust even. But yeah, I think most lawyers will charge less for a will than they will for a trust. And some of that is the complexity. Some of it is the benefit to the client, right? Yeah. Generally, I would say that trusts typically cost more than wills because we don't want to do without a will. When you get a trust, you also will get a will. And the will is what's called a pour over will. It says anything I forgot to put in my trust, at the time I die, the will catches it and puts it into the trust. So it might have to go through probate still, but at least the trust distributes it the way you want it distributed for any assets that were not yet in the trust. So there's that cost element because you're adding to not replacing.
All right. So now that we got that out of the way, if you have a will, need to quickly get a trust, maybe take us through what the trust can be, and we can start with the simple one and then we'll work our way through the more complex ones throughout this
Sure.
webinar.
So, yeah. What is a trust, right? The trust is agreement where someone holds property of some type for the benefit of someone else. That's the simplest concept of a trust. And where a lot of people get confused is they just hear, oh, I heard that I need a trust, but they don't know what kind of trust or what it should do. And this is where they might get thrown off. The trust that most people start with for their own estate planning is called a revocable living trust. And what we mean by that, when we say revocable, that means you can cancel it at any time. Living means you're creating it during your lifetime. Technically, you could put words into your will that would create a trust when you die, and the will still has to go through probate, but then out of the probate, it creates a trust for the benefit of someone, and that's called a testamentary trust. But what we recommend for most people is to have a revocable living trust as the base for their estate plan to hold assets that they're keeping during their life, to be able to pass on the management of those assets when they become incapacitated or pass away, and let someone else step in to manage those assets for them.
You did good on the easy questions, the first softballs, but now we're making it harder for you. And this is what I like about you. You like these more complicated, exotic stuff.
Hey, I'm happy to
Our
help.
irrevocable trust, right? A little bit more expensive and a little bit more protection. Why is that? I guess so people understand what the difference is here.
Sure. So with an irrevocable or irrevocable trust, that's one that you cannot cancel. Once you've created it, you can't just cancel the trust and take the assets back for yourself. And the main purpose for most irrevocable trusts traditionally was for estate tax planning, to move assets out of your name, out of your estate, so that when you pass away, it's not included in your total assets to see whether there's a death tax or inheritance tax. So that's the main reason irrevocable trusts were usually originally used. There are some variation that aren't specifically for that purpose or even intentionally do not work in that way. With a revocable trust, you have the right to cancel it at any time, use those assets for yourself, and you haven't done anything to give it away yet until you pass away. So you can always amend the trust and change who's going to inherit after you die. With the irrevocable trust, you're giving up a lot of control, ownership, and rights over the trust. That's where there's many different flavors of irrevocable trust that are used for specific purposes.
Because at that point, should you get sued, it's like, hey man, ain't mine. I gave it away. That's the
Exactly.
general premise.
And historically, you could not create a trust for your own benefit, put your assets into your own trust, and have it protected from your creditors, even if it was irrevocable. You could do that where you put assets into a trust for the benefit of someone else, your spouse, your kids, friend, or someone else could do it for you. Your parents could create a trust for you, make it irrevocable, and you're not the one that funded it with your own assets, even if you are the beneficiary, or vice versa. You do fund it with your assets, but you're not the beneficiary. Someone else is the beneficiary. And that's how it provided protection from creditors and lawsuits. And in recent times, since 1998 in the US, there are a handful of states now where you can create trusts, fund it with your own assets, and have it protected against your creditors. We call domestic asset protection trusts.
And I think for the most of people listening to this podcast, most of you guys are above $1 million net worth. That's probably what we'll be zeroing in later on in this webinar. But I guess so, like the next book that's coming out is called The Wealth Elevator. And it's just, I just didn't pick that term because it just shoots up to the penthouse. There's different levels to this building. And same thing here, like at some point, if you're broke, you don't got any money, or you got some money, then like a will, then a trust, then irrevocable trust. Just, I guess, I don't know, everybody's different, right? But like generally, what would you say? Like, hey, you have this kind of net worth or this type of liability, or what is your kind of real general advice of what to actually learn about? Because I think that's hard for a lot of people. People will hear all kinds of strategies out there, like flipping houses. That's what you do when you're under $1 million net worth, in my opinion. It's too much work, just like how certain revocable trusts may be not enough asset protection for a guy over 5 million. But how would you build
That's
that?
a great question there, Lane.
Because we don't like to waste people's times, because that's the hard part is there's so much noise and all this stuff out there. do you say?
Yeah. So generally, I would say if a person owns any real estate at all, or has, let's say, 100,000 in non-real estate assets, they don't own any real estate, they should probably have at least a revocable trust. That's a threshold where the will is not sufficient. And I use that number for Hawaii because if you have 100,000 or more and no real estate, you still have to go through probate in the state of Hawaii. It may be different in your state. So that's something to look into. Above that, when we're looking at creditor protection, if you've, like Lane, you suggested $1 million in net worth, you probably worked hard for it and you probably want to protect it from potential creditors and lawsuits and whatnot. It may make sense to look at an irrevocable asset protection trust in that scenario. And it doesn't even have to be $1 million. I know that one of the most famous cases about this creditor protection was out of Alaska, where a fellow only had a home worth about $250,000 or $350,000 in his primary residence, and he put it in an asset protection trust. Unfortunately, it was one of those examples where he didn't operate it properly, and so it didn't end up protecting him because the facts were bad. Kind of like with your LC, if you don't run it correctly, or your corporation, then you could pierce the corporate veil and lose the creditor protection that's supposed to come with it. But that was one where there are those who only have a few 100,000, and for them, it's everything they've worked for and they want to protect it. And it could make sense for them to have an asset protection trust as well.
So it's the second, what about like how much these things cost, right? Because as you start to go up the levels, like
Yeah.
the wills, like you can get that under what, $1,000, and a trust 1,000 to a few thousand. Is that kind of the street prices nowadays?
Yeah, typically it'll be a few $1,000s to set up a revocable trust plan, and usually it'll include the will and a power of attorney and a healthcare directive to be a complete estate plan. And if you have real estate, you'll need deeds as well to transfer the property into the trust from your personal name. So a few $1,000s is typical, right, for a trust package. When you're looking at the asset protection stuff, it can range. I'd say the average I've seen is about a $10,000 price just for the trust. And sometimes it can be more because the protection structuring will often include using LLCs together with the trust or other methods of protecting your assets, maybe a limited partnership or something like that, a personal family limited partnership. So depending on the scenario, it could be a little more than that, but that's where there's some investment in that protection.
Yeah. What's the most expensive, craziest trust
Okay.
unbuster system you've seen? Like,
The most expensive estate plan, say, that I've done has been about $100,000 for one client's scenario at once. And another lawyer had actually quoted them 250,000 to do the same thing, but they own a lot of real estate. They had about a $40 million net worth, so not like billionaires or anything, but there were a lot of parcels of real property involved, creating an irrevocable trust for the benefit of the descendants that was legacy dynasty style, could continue on forever, setting up a family limited partnership style limited liability company to own the parcels of real property, deeds to transfer everything into them, coordinating to get the valuation, discounts on the estate tax, basically helping them to save with estate tax planning along with the creditor protection structuring and moving everything together. It's a lot of moving pieces when you have 40 parcels of real property and a lot of in multiple different states and different entities that own it to begin with. So coordinating all of that was a lot of work, but the benefits to the client were more than $10 million in death tax savings. When you look at it that way, it's 1% cost on the
yeah.
savings.
Yeah. And we'll get into the estate taxes here in a few slides. But once you start to talk about getting around state, federal estate taxes, you already know that we're talking about guys that are above $10 to $20 million net worth, which brings up the point. If $10,000, $20,000 seems a lot for a trust document, then you probably don't need it. Although I think more often than not, they try to get a higher level of protection than what their pay grade is. But hey, I'm not a lawyer. That's why I bring you guys on here. Let's dissect like the pieces of the trust. So like this, hopefully this will allow people to have educated conversations with their lawyer, or this is what we do with the CPAs, right? A lot of the CPAs don't really know how to do the taxes the right way, especially with a gazillion K1s and passive losses. So it really helps if the investor is educated and empowered to have these conversations, to do due diligence on your vendors.
Sure. So every trust has three parties. The person creating the trust, we usually call the settlor. Sometimes they say the grantor or trustor. It's all the same thing. I've even seen trust maker as a term. But generally, the settlor is what the person is called who's creating the trust. And when we say creating, we're not talking about the lawyer who's drafting the document. We're talking about the person who's putting their assets into the trust, the client, right? The trustee is whoever's going to manage the trust. And with the revocable living trust, usually the client is both the settlor and the trustee who manages it initially. And so you give the assets to yourself in the role of trustee. And then the third party with every trust is the beneficiary. The beneficiary is the person for whom the trust is set up, person that the trustee can give the assets to. So with the revocable living trust, you are all three parties. You're the settlor, the trustee, and the beneficiary. And you might think, why do I need to set up a trust if I'm the one that's creating this trust? So it's my assets to begin with. I give it to myself as trustee, so I'm the one managing it. And then I can take it out of the trust for myself as a beneficiary. Why did I even need the trust? It's all the same. The key here with the revocable trust is if you were to become incapacitated, then a successor trustee, your spouse, your kid, your best friend, someone can step in to manage the assets for you while you're still the beneficiary while you're alive. So it's still for you, but you don't get to manage it anymore because you're not competent to. So another trustee can step in, and we don't need to go to court for a conservatorship hearing to do that. That's like probate while you're still alive. And if you pass away, now you can't be the trustee or the beneficiary anymore. You will always be the settlor / grantor trustor who created the trust. But once you've passed away, now it's for the benefit of someone else. And this is where we avoid probate. So it's an easy, smooth transition without having to change the ownership from your personal name because the trust can still own it. And all we're doing is changing in who's managing the trust, not the ownership of the assets. Now, with a revocable trust, I mentioned you are usually the trustee. With an irrevocable trust, usually you are not the trustee. Usually you can't be the trustee in order to accomplish many of the things we want to accomplish with irrevocable trusts, like creditor protection or moving things out of your taxable estate. So in that case, you might have a best friend or even a spouse in certain circumstances, or the bank or trust company or someone else who can manage a professional. Sometimes lawyers or CPAs will act as trustee and manage the trust. And in the case of a domestic asset protection trust where it's for your own benefit, you can be one of those beneficiaries. Although you have to be really careful about estate tax planning when you are a beneficiary of the trust. Otherwise, if it's for anyone else, it could be a little less critical. Yeah, we have someone else stepping in as trustee, someone else's beneficiary. You've relinquished control. You can have that to move it out of your estate as well.
This is all to get to that Rockefeller. They say, control that $500,000 Ferrari. And if you get into an accident, you didn't own it, right? You just controlled it. And thus, it's that trustee that kind of gets played around with it. But the beneficiary is you, right? That's typically how it works.
With the revocable trust and the asset protection trust, absolutely.
If you want to take it a step further, you change the settlor also, right?
Yeah. So usually the client is the settlor of a trust. Then often, depending on the type of trust, they may or may not be the trustee. They may or may not be the beneficiary, right? They might be setting it up to benefit their spouse or their kids. We have something called a spousal lifetime access trust, where you move assets into a trust for the benefit of your spouse. And it's out of your taxable estate and it's protected from your creditors and your spouse's creditors. So neither of you own it anymore. Now the trust owns it, but it's for the benefit of your spouse, right? So you're right, that can happen. Coming back to changing the settlor, a newer technique that some attorneys, I wish I were smart enough to have thought of it myself, but we've implemented at times, is have the older generation, maybe we have a successful younger person whose parent isn't going to use up their total estate tax exemption because the parent doesn't have 12 million. We might have a trust where the younger generation sells or gives assets to the older generation who then put it in trust back for the younger generation eventually. And that can also protect it for your benefit, even though originally it used to be your assets. There's a lot of complications and technicalities with doing that correct to make sure it works for income tax purposes as well as estate tax and creditor protection purposes. But yeah, you could have a settlor who would be your parent instead of yourself, where the settlor is someone creating a trust for your benefit.
Because I guess when you get sued, it's like a street fight is how I've heard it said. And yeah, you might have set up a traditional irrevocable trust with you not as the trustee. But as they start to dig into it, if you're the one who set it up for yourself, that creates somewhat of a vulnerability.
Yes. Let me get deeper into that. As I mentioned earlier, historically, you could not set up a trust for your own benefit and protect it from your creditors. Under English common law, this was deemed to be an attempt to defraud your creditors. Fast forward to the early 1980s, and the Cook Islands, small South Pacific island nation, for the first time in history, passed a law saying that someone could create a trust, have it be for their own benefit. So they're the settler and the beneficiary. And as long as it's irrevocable, and as long as it uses a Cook Islands bank or trust company as the trustee, then under Cook Islands law, it would be protected from that person's creditors. So this was the first time you could create a self-settled asset protection trust, a trust that was protected from your creditors, where you created it for your own benefit. And that changed hundreds of years of common law, trust law in the English tradition. And so fast forward again from 1984-ish to 1998-ish, and the state of Alaska said, wait a minute, everybody who's looking for this strong asset protection is moving offshore to the Cook Islands to get this asset protection trust, or maybe some other jurisdictions that copied them. We're a state, we have our own legislature, we can pass our own laws to write over the common law and change that. Let's get our legislature to write a law saying that in Alaska, we can create a trust, be the settlor, be the beneficiary, and as long as you're using an Alaska resident trustee, whether an individual or a bank or a trust company, and it's not yourself, then it can be protected from your creditors. And that was the first domestic within the US asset protection trust law. And quickly, a handful of other states followed suit, from Delaware and Nevada and South Dakota. Those are probably the four most popular states. They've been around the longest in that. Hawaii happened to be the 13th state to do this back in 2011. And since then, there have been a handful more of other states that also have this type of a law. And this is where you can create a trust that's protected from your own creditors. Complication comes in where, what if you create a Hawaii asset protection trust, but you're a California resident? The state of California is one of the states that has not yet passed a law allowing for self-settled, self-created asset protection trusts. So what is a California judge going to say about a Hawaii asset protection trust? That's up in the air, right?
You dummy, right? You just bricked your whole trust, right? Or potentially, right?
Possibly. So yeah, in that case, there are other strategies we can use to use traditional common law that's available in all 50 states for the protection of the assets from creditors by not having you as a beneficiary initially, even if later on we might add you as a beneficiary if need be, or have access through a spouse if you have a really good relationship where you're sure you're not going to get divorced. Although 100% of marriages, I would guess, or close to it, start off not planning to get divorced, and about 50% find out that they were wrong. So I wouldn't rely on that if you weren't proven the test of time yet, but that's another possibility.
I think this also brings up another point. So listeners out there, most people are looking for that ironclad thing. There is none. There is, just shades of gray, and it's getting darker. It's getting darker, and it's much more costly. And something that I personally don't like is it gets really complicated, where it gets so complicated that you mess it up. Because after this thing gets all set up, it's pretty much just you potentially jacking it up and being your own worst enemy, not following the directions properly. But
This is where I like to recommend to clients to do some kind of annual maintenance plan with their provider if they offer that. Some attorneys don't. They just want to sell a package. Here's the trust, I'm done. And they move on their way and they go for a high dollar sale again on the next client. The good providers will help you with guidance over time so that when you have questions, they can answer it. You can come back in, and even if you don't have questions, they can look at it and see and make sure you're not messing things up. They can work with your CPA to coordinate the income tax side of things. And so that's one helpful element. But you're right. A lot of times you are just on your own. And so the more complexity you have, the more you're setting yourself up for failure.
And I did want to point something Ethan said there, right? Like a lot of times what's happening here, and I get this all the time, like people will bring up, oh, have you heard about Trust XYZ, Special Dynasty, East Indian Trust, whatever, all these crazy marketable terms. A lot of this is what's put out by legal promoters, guys who are not even lawyers, but they're just selling these legal intellectual property, these documents. Or I think of it more like computer programs, like a computer code. It's this 300 pages of trust document language that got created into this IP, intellectual property, and then licensed out to other people. But your guys' profession is pretty prevalent with this legal promotion stuff, right? It's hard for the consumer.
Unfortunately, yes. And the biggest problem I see is we live in such a commoditized world, right? Nowadays, if you say, I want to get a 55-inch screen TV, you go to Costco, you could pick up Vizio or Sony or Samsung or whatever, and it's the same to the consumer, even if there are technical differences between them. But that's not the case when you're buying professional services, right? If you were to say there's a $700 version and a $5,000 version of a heart replacement surgery doctor, you want to know who's going to be doing it and how good they are at doing it. It's not a commodity. Likewise for your CPA, likewise for your attorney, what's their experience? How can they customize it for you versus selling a generic? And to your point, with the legal industry, there are all these who are not attorneys, just selling cookie cutter, commoditized style document that they replace your name and address in, but may not exactly fit your scenario, and they're not customizing it specifically for what you need. And that's where the difference between, say, an off the rack versus a tailor-made suit, there's a significant difference when you actually do that. But for some people, maybe a generic simple thing is adequate. So I don't want to knock it completely. It just depends on your circumstances.
Yeah. I'm big like using a CPA remotely because a lot of that's electronic documents, and call me more like non-conservative on that front. But the one thing for like trust, it's not you guys out there who devour podcasts and books and are financial fanatic. It's your poor heirs that you leave behind, clueless with your crazy spreadsheets that nobody can understand. Nobody understands your guys' spreadsheets. You guys stay up for like hours making your spreadsheet. Nobody cares. Nobody knows what you're doing with that thing. You're wasting your time. Anyway, that I see that myself. I spent so much hours in my 20s just making my network spreadsheet that nobody understands. And if I can see it today, if I died, nobody would have been able to make any sense of it, just like the trust, right? That's why you need to work with somebody in person to make sense of this. And this is why it makes sense to work with somebody local and somebody who you have that personal relationship with, because if not for you, it's for your heirs that are left behind. And
That's a really insightful comment there, Lane.
yeah, but anyway, don't buy one of those off the shelf suits that don't work. And that's why we beat this slide to death, because it's important for everybody to understand these three things here. We have all
Flavors of
these.
irrevocable trust.
Yeah, this is alphabet soup here. These aren't necessarily those marketable trusts, fancy, but these are like, maybe if you can explain, like, is
Sure.
this like different permutations and commutations of settlers, trustees, beneficiaries, basically here?
Yes, yes, I'll get into it further. So, like you said, alphabet soup. And I have to say, I'm one of the first to say lawyers are terrible at coming up with marketable and easy to use names, right? So, a lot of our terms with trusts are complicated and confusing and even misleading in the sound of them, because it makes sense to a professional who's in the field, but the layperson would have no idea what we're talking about. So, if you've heard of an ILIT, Irrevocable Life Insurance Trust, or a QPRIT, a Qualified Personal Residence Trust, or a SLAT, Spousal Lifetime Access Trust, or IDGIT, an Irrevocable Defective Grantor Trust, the BDIT, the BDOT, the CLAT, CRUT, NIM, CRUT. There's so many different marketed names for trusts, and it's not like there's just one of these. Any trust that is designed to do this specific function, prepared by an attorney who's competent, can fall into that category. And all of these ones I just listed are irrevocable trusts, not revocable. So generally, you wouldn't be the trustee for most of them. But let's take, for example, the first one listed, an irrevocable life insurance trust. The concept there is to say every year you could give away, it used to be 10,000 per person per year. Now it's 17,000 per person per year. So you could give 17,000 to each of your kids and each of your grandkids and try to whittle down your large estate in that way. If you have a $40, $50 million estate, sure. And most of our clients who have large estates, they got it by either business, so they own stock in a business that may be a closely held family business, or through acquiring real estate. And either one of those is not very liquid. So when they pass away and if there's a death tax, how do they pay it? They have to fire sell off their asset and maybe at a loss. So one of the solutions is to have life insurance to cover the expected death tax. And the problem is if you own the life insurance yourself, then you have to pay death tax on the value of the life insurance that comes in when you die too. So how do you not own the life insurance, but make it available to pay your tax? You set up an irrevocable life insurance trust where the beneficiaries are your kids and grandkids or spouse, and you can put $17,000 per year of premium for each beneficiary to pay the premiums on the life insurance. When you pass away, there's a big payout, and then that can be used. So each of these tools is for a specific purpose. The qualified personal residence trust is how to move your residence out of your name into a trust that you get to use and live in for 10 or 20 years or some term. And then after that, it's not owned by you, it's owned by your heirs, and it reduces the estate tax burden, right? So I don't want to get in too much in the weeds and how each of these work, but they're all just types of trusts that can be used to minimize your death tax and or set up some creditor protection through the irrevocable trust system.
One thing I wanted to zero in on that was a kind of a take home for me was this, I think it's the grantor word. I invest in real estate that gives me a lot of great passive losses, deductions that I use to pay no taxes. I want that to pass through to me. So we went with an approach that did that for me. And then the idea was later on when I'm not doing active real estate, or maybe I'm just throwing my money into T-bills at that point because I've got a gazillion dollars. And I don't care because I'm dead. Then we flip-flop it like a non-grantor trust. So everything is encapsulated in that trust. Is that the word? The grantor pays the taxes? Or
Yes, I love how simply you were able to put that, Lane. That's brilliant. So earlier we saw that grantor was one of the names for settlor, the person creating the trust. But grantor is also a specific term regarding trusts that has income tax consequences. So whenever we look at a trust, it's going to be taxed one of a few ways. If it's taxed as a standard irrevocable trust, something they call a complex trust, that irrevocable trust has to get its own EIN, employer identification number, tax identification number, file its own income tax returns on any income that it earns, and it can, of course, take deductions and expenses as well. But the problem is that a trust will be taxed at the highest income tax brackets when it only has about 14,000 of income for the year. And so an individual can have several hundreds of thousands before it's in that bracket, right? So generally, there can be an income tax disadvantage for a standard irrevocable trust to be paying its own tax at its own rate. Where if the trust hits certain features that the grantor creator has, then it's considered a grantor trust is the magic word. And that means the income tax consequences flow back to the creator of the trust. And therefore, when the trust has any income, the trust doesn't actually owe anything or file its own return. The creator of the trust is the one that owes the income tax and has the consequences. And that allows for some really interesting opportunities. If you see the third item on the list here, installment sale to a grantor trust. If you're trying to move assets out of your estate, but not use up too much gift tax exemption, you could sell assets to the trust at fair market value. Unfortunately, if you sell your appreciated real estate or your business, your personal company stock that's grown in value since you created it, you would normally have a capital gains tax. When you sell to a grantor trust, the IRS treats it as if you're selling to yourself, which means no capital gains tax. But the property laws say that you're not the owner anymore. It's now owned by this trust, which if you're not the beneficiary of, it won't be included in your estate. So it's another really powerful tool to move assets for estate tax and or creditor protection purposes and not have to have a big income tax problem and not pay income tax on just the highest rates at 14,000 of income in the year. So that's exactly right. The grantor trust status is something really useful that can be turned on and off.
the beneficiary, which may not be me.
Yeah. So if you notice right under the installment sale, the grantor trust, the beneficiary deemed owner trust is a specific special flavor of a grantor trust, where instead of the creator of the trust, it's the beneficiary that is the one that's deemed to be the grantor, the owner for income tax purposes. So yeah, these are all highly sophisticated techniques that the best estate planning attorneys around the country will all be using. And not every estate planning attorney will be able to set up all of these. A good, competent attorney should be able to do the first couple probably. And then again, I've come across estate planning attorneys who say, I won't even do an irrevocable trust, period. I only do revocable trusts because it's super simple and I'm not worried about the tax consequences.
Yeah. So two things here, right? We have estate protection, which is, I think, what we were talking about mostly up to this point. But now we're bringing in the second part, which is taxes. So there's two things here. So I don't see the title here, but there's also out there like floating around, like I have your cake and eat it too trust. I don't know exactly what that one is. Like, 'cause that's like a B dot. But anyway, now we're moving off into the estate taxes where every state's different. But I want you to take us through here because not a lot of people hit this at the moment. Most of the people listing are mid 40 net worth of several mil, not hitting these things yet. But if you guys double your money every 5 to 6 years, you'll be there by the time you're 50, 60 at the latest, I'm thinking.
So that's one of the concepts that a lot of people miss. They think, gee, the estate tax exemption, how much I can die with and pay no federal tax, is really high. It's over 12 million, 12.9 million this year. And so I don't have to worry about this. I only have 5 million or whatever the number might be. And I'm married, and between my spouse and I, we each have this 12 million. So we could have 24 million exempt. One of the big problems is that the estate tax exemption on the federal level was doubled in 2017. If you look at this chart, December 2017, they passed the Tax Cuts and Jobs Act, where Trump said, I'm going to double the exemption from death tax. And of course, to get Congress on board, right, the opposition said, we'll allow this doubling of the exemption, but it's not going to go on forever. December 2025, this law will expire and we'll go back to the 5 million adjusted for inflation. So right now, this chart looks pretty groovy at 12.9 million, which would be, say 6.46 or something if it weren't doubled. And that's what's going to happen, say, in 2026. We're going to be back to the 6 million, not 12. So that's one factor, is it's going to get cut back in half unless Congress can agree on extending it or doubling it further. And as you're appreciating, hopefully you're all investing your assets in a way to double every handful of years so that you will exceed this at some point. And that's the goal. So we want to plan on how to not have an estate tax when we die. It's much easier to do so when you're under the exemption and you can move assets away out of your estate, as opposed to after you've already exceeded it. And then, what might have been 25,000 in legal fees turns out to be 100,000 in legal fees after the fact to try to save it later, right? If you can do it all by then.
And in addition to this, we also have the state tax, which could be worse, or maybe there won't be any, but that's another thing to think about and why you want to work with a competent person in your local area.
Right. Any state that you own assets in, if you have assets in the state of Hawaii, you might be subject to the Hawaii death tax when you pass away, even if you're not a resident here. Also, just some other things to consider. If you have a non-citizen, if you are a non-citizen, not a U.S. citizen, or your spouse is, then the exemption from estate tax is not 12 million, it's only $60,000. And everything above that 60,000, you're paying the 40% death tax on. And there's a limit to how much you can give to your non-citizen spouse. So there's not an unlimited marital deduction, which usually would apply. So extra complications if there's a non-citizen involved, even if they have a green card.
Yeah. But nobody's getting divorces, so you don't have to worry about that one. And nobody's going to get married to anybody that's not from America. Moving
Right.
on. Yes, again, the alphabet soup, but these are, correct me if here, Ethan, but these are the more sophisticated ways of talking about these trusts than if you walk into the guy's office and being like, oh, I want the Mastery Select. I think that's like the Hibiki Japanese Harmony kind of whiskey or trust. Give me that one because you saw it on some ad or something like that. You're going to know, you're going to review your cards and your level of sophistication here. And he's going to figure out what your net worth is and slap down just a regular off the shelf living trust. But if you can understand, like Google, if you guys want to Google these terms on your own, try and at least read it once or twice. I think that will cut down on a lot of billable hours at least on this stuff.
Yeah. And like you mentioned earlier, Lane, many attorneys will custom brand, or even non-attorneys, they will brand their own flavor of trust. You can have your cake and eat it too, or whatever it might be. And it might fall into one of these categories, but they want to come up with something that's unique to them. So when anyone asks about it, the other lawyers, I don't know what you're talking about because it's not a term we use in the legal community. Someone called it that. An example would be Lane comes up with a limited partnership investment and calls it the how to get rich limited partnership. And if you went around asking people, hey, I want to invest in a how to get rich limited partnership, you're like, what are you talking about?
Yeah.
It's just something that you brand on your own. And so a lot of that is something to be careful of too, where lawyers and non-lawyers will advertise and market something on the internet that sounds great, but it's just a marketing term they came up with that might be applying to one of these traditional concepts.
I don't know if this hits your world, but like in, I see a lot of these like solo 401k. They're solo 401k is all it is. But
Mhm.
people take this documentation and they make 50 different marketed ways of doing it, just changing one word probably in it. And then now you have all these branded
The
terms out
super
there. So
retirement plan. Did you get your
yeah,
super ultra retirement plan?
yeah, yeah.
Yeah,
This
it's a
one's
separate
exempt from
thing.
UBIT and UDFI. Make sure you get that one on there.
Yeah,
That's
yeah. When really it's just simple differentiation from your self-directed IRA as
yeah,
a solo 401k, but
yeah.
they can try to brand it and name it whatever they want. Yeah.
That's our business. I'll get one of those documents from one of my guys. We'll just copy it and then you just got to take ownership over it and we'll just license the heck out of it. Well, we got to think of some kind of term because a lot of them are taken out there. But that's the financial industry, guys. Financial services for you.
Yeah. And this is specifically to Hawaii. If you're trying to figure out what your federal and Hawaii state death tax would be, this is the number that you'd be looking at between those. But how to avoid gift tax during life. And so some of these slides may not apply, but one thing to
Gen-
note is that the death tax and gift tax are a combined thing. So anything you give during your life that's more than the 17,000 per year starts to eat up your death tax exemption.
yeah. So there's a way to gamify it to strip it all away from
There
eating into
is
your number.
there are ways to actually reduce the value of what you're giving away. And some of that alphabet soup kind of touches on that, but it has to be done precisely correct or it doesn't work, right? So there are a lot of ways to mess it up so it doesn't work. And there's one right way to do each of these
Yeah.
techniques.
I guess that probably went over the head of a lot of people. But what Ethan's basically saying is an asset goes out, not money, but an asset goes out. And the value of that is somewhat subjective. So it's similar to what some people will do. They'll put something in their Roth IRA and they'll get it appraised for 50 grand. But the thing is worth 350. It's on that same premise, not using those numbers exactly, but you can get this is I think where you need to work hand in hand with your estate attorney because there's a lot of these techniques that are very legal that a lot of people do to keep it in the family.
Yeah.
Is this the AB trust conversation here?
Yes.
Okay. This is I call it I got a better term for you than AB trust. It's the wildcat offense. We pitch it to the husband or we have the wife run it in. Depends.
I
But
love it. Yeah. So this is comparing the traditional give everything to the spouse, the I love you plan all to each other without the trust versus, or even with a trust, but not the AB versus the next example would be with using an AB trust, right? So we say, hey, yeah, if everything goes to the spouse, wife gets the whole 11 million. She dies, it's under the 12.9, no death tax. But then after she dies, Hawaii, there would be a death tax because it's over the 5.49 million Hawaii exemption. With an AB trust, the idea is that when one spouse dies, we don't want to waste their exemption. We apply their exemption to the assets in their trust. And even though it's available for the spouse to use if needed, the spouse doesn't actually own it. So in this slide here, you look at the B trust, husband uses up all his exemption of 5.49 million, at least the Hawaii exemption amount, and there's no tax on that when he dies. The rest that's over that we don't want to pay a Hawaii tax on. So it's available for the spouse in something called a marital deduction trust. So the spouse gets the exclusive use of those assets during her life, and that will be taxed in the spouse's estate when the spouse dies. But there's no tax when the husband dies, even though he's over the Hawaii exemption. Now, for the B trust there, that's not part of the wife's estate, she can still use it if she needs it. When the wife dies, we have everything from her assets plus the A trust that husband's trust left to her, leaving no tax, just about no tax by the time she passes. And for the B trust, that's not taxed as part of the wife's estate when she dies, even though she could have used it all if she needed it for her health, education, maintenance, support. So basically, the kids get all of the assets and there's no state death tax here. Same thing would apply even in say, California or a state with no state death tax, but they have a federal tax and they're above the exemption amount. The concept applies across the board.
yeah. So call Ethan because things will change and then Ethan will have his spreadsheet or your lawyer should have the spreadsheet that'll tell you what's the smartest thing to do.
Yeah.
Conservatorship. This is a little depressing.
We hate to think about it, but if something happened to you and you didn't pass away, you got in an accident and it made you disabled, or you got dementia or Alzheimer's or whatever it might be, you have something where you can't manage things anymore. Someone has to make medical and financial decisions for you, or for your minor child, or for your family member. So, how do we deal with that? We don't want to have to go to court and let the judge decide. Typically, having a trust set up will mean that you have someone who can step in and manage it for you. And if it's for your kids or something and you want to protect it from them, they might qualify for government benefits based on their disability. But if the trust is available to them, then that could disqualify them. We want to have what's called special needs trust or supplemental needs trust language that would allow the trust to exist for the benefit of the beneficiary, but not disqualify them from getting government benefits they would otherwise be entitled to. So that's something we try to include in our trusts just in case.
I mean, there's like so many different situations, but what would you say is like the normal strategy for somebody in their 70s, 80s? They're living in the house. There's only probably one spouse at the time because actuary tables say one spouse is probably going to be gone. And then the nursing home comes into effect. Like I hear all kinds of strategies with draining out their estate so that now they can be awarded to the state. What are people doing with more than $1 million due with this stuff?
So there's a handful of things that can be done. And this is something we specialize in. And I would highly recommend whatever state you're in to get a specialist in this. I have seen clients that went to one of the top law firms and they billed hourly for 8 months, racked up a bill of about $90,000 for the client and accomplished zero. And then they came to us and we were able to, for a $20,000 legal fee, help them save about $1 million in assets with some of these strategies, but it really takes a specialist. So that's something you want to look for. One of the easiest things is just give away all your assets and wait 5 years. If you've given it away more than 5 years ago and you don't own it, your kids own it or whoever else owns it, then it's not your asset and it's past the look back period to apply for Medicaid government assistance to pay for long-term care in a nursing home. So that's the simplest thing. If you have a crystal ball, I would say 5 years and 1 day before you go to a nursing home, give everything away, right? Simple.
People don't plan. People don't do that, man.
Yeah.
I don't do that.
And so if not, there are lots of other things that can be done to save assets, especially a primary residence. If you have a child who's lived there for 2 years with you, or a sibling who's lived there with you, or a disabled child, and even worst case scenario where you've given nothing away, you can pretty much save about half the assets in almost every situation, even if it's less than 5 years. Yeah, there's a handful of techniques that we can use. And depending on the state, if you're in California, there's very liberal rules about giving away assets and qualifying for the long-term care. So it's a lot easier to save assets even in California than maybe most of the other states at this point. But that's something I would say, again, see a specialist on. But there are things that can be done. The most important thing I would say for everyone to know is before you're incapacitated, before you become incompetent, do create a durable power of attorney, a financial power of attorney that allows someone to act on your behalf and that allows them to make gifts on your behalf when you're incompetent. Because under most states' laws, they either can't take away your assets and give it away to someone else, or they're limited to maybe the $17,000 a year or 5% of your total assets or something like that. And those restrictions prevent us from implementing the best nursing home cost planning techniques. So we want to make sure you have a good power of attorney with someone you trust that allows them to give your assets to your loved ones, even if it drains you of all your assets. And that allows for that planning to take place.
I will also throw in another strategy I've seen clients do is you don't want your house to appreciate more than $500,000, guys. Sell the house, buy another one, and then move back in. I don't know, whatever. But that $500,000 exemption is one of the sweetest and probably the only ways you can not defer taxes, but extinguish them. I actually hear that might be going up now to $1 million or more adjusted with inflation. Most of the people who are nursing home age nowadays, they bought their house for 50 grand and now it's 800. And if they sell and they're selling because they're forced to pay to get into the nursing home, now they have to sell and have to pay taxes on the delta of that the excess of 500,000, which is a shame. But hey, I guess that's it. We're all taught by our parents, buy a house, pay it down. But I think personally, that was a lesson learned for myself. I was just going to try and buy the biggest house I could at one point. But then I was like, wow, I got to pay taxes on it if I ever want to move up. So I was like, now I changed my strategy to leapfrog. $500,000 or maybe a little bit more than that every single time. But that's something that gums up a lot of people because when you do it the traditional way, you're going to be less than $1.5 million by the time you're 80 years old. So you're not going to have enough money to pay for this stuff. And I also see a lot of our clients stepping in as the person to fill the gap and the person who at risk goes in case mom and dad lives longer than they're expected to fill that gap. It's very common. And that's why I come to the events and meet other people for people who have agreed to do that and take on that responsibility. And you guys can have a pity party together and talk about this stuff. But
One other thought, if I can share on that too, Lane, what you brought up about the 500,000 gain that you can exclude for married couple filing jointly. Yeah, there's a lot that can be done with that. And I've had situations where client passes away. And like you said, actuarially, one of them might be surviving. The surviving spouse can sell within 2 years after death. And as long as they met all the requirements before the spouse died, you could still claim the 500,000 for the married couple instead of just the 250,000 of a single person. So it's something to consider of selling within the 2 years after one spouse dies to get the bigger exemption. Then the other thing is getting a capital gains tax stepped up basis when the first spouse dies, being able to take advantage of that and not sometimes people just remember what they bought it for and they don't think about claiming a stepped up basis on the first spouse's death to help increase the basis for that half of the property for the survivor when they're selling. Hopefully that wasn't too confusing here.
it's a little depressing. Let's skip ahead some of this nursing home
Yeah.
stuff. I think that's talked with
Yeah.
an expert because it changes, right? It changes all the time. Let's
That's right.
talk about something more positive, like really
Sounds good.
sticking it to your son and daughter's husband or wife that you didn't like that they get a divorce with. Generation skipping trust.
Yeah. And that's another example of a terrible name that lawyers came up with. The average person who hears generation skipping trust thinks it means you skip a generation and you don't leave things to your kids. Instead, you leave it to your grandkids. That's not technically what this is. Generation skipping trust is a short name for generation skipping transfer tax exempt trust. In other words, whatever goes into this trust isn't subject to estate tax when it goes down through multiple generations, and it's not subject to something called the generation skipping transfer tax. Right? It's another unheard of tax that most people never even knew about. The main point here is to protect the inheritance. So when it stays in trust, your children could be trustees to manage the trust and be beneficiaries of the trust and take out what they need when they need it. And yet, when they get divorced, their spouse can't touch anything in the trust because you left this for your children, your grandchildren. It's not for your in-laws. When your child dies, right? Instead of leaving everything to their spouse, which is what they normally do in their will, if you left inheritance directly to your child, likely it would go to the spouse. And if the spouse gets remarried to some foreign citizen who's 20 years old or whatever, now your grandchildren get cut out of the inheritance when that spouse dies and leaves everything to your in-law's new spouse. So this trust is designed to protect it by keeping it in the family line. So when you pass away, the trust splits up into shares for each child that you might have. They get their own GST exempt trust share. They can take out what they need. They can be the trustee and the beneficiary. When they pass away, their own share has to stay in the family line if you want it to. You could give as much flexibility as you want for the child to leave it to whomever they want. But most of my clients would say, keep it in so that the grandchildren get it after my children. And if they have one rotten grandchild, the kids can decide what percentage or how much goes to each, but it has to stay in the family line, right? So that's the beauty of this. Sometimes it's called a dynasty trust when it can continue on indefinitely for many generations.
And this is like an add-on to the other trust. So like this, when I was making my trust, I don't even remember what we got. BDET, whatever. We picked one of those cool, really fancy, exotic, irrevocable trusts. And then I thought we were all done. It's kind of like you buy a car and then you got to go to the financier's office and pick a warranty package. This is like the add-on after it, how the money is distributed. 95% of people do. Why would you not do this? I guess.
I would say if you have more than 100,000 to leave to each beneficiary, it makes sense to do it. And the reasoning behind that is for many of my clients who may not even have a lot, they have a home in Hawaii worth, let's call it $1 million, and 2 kids. So they're each going to inherit $500,000 in value. They might sell the house and have cash. They might keep the house. Either way, they want to protect that 500,000 because their kids who are working and saving struggle to save more than $5,000 or $10,000 a year. The average person who doesn't have a super high income, it would take them a lifetime to save 500,000. and that's worth protecting. So when it's not, when you have maybe only 100,000 to leave and you've got 8 kids to split it amongst, it doesn't make sense to set this up because they should just get their $10,000 inheritance and walk away with it and spend it or whatever. But that's the difference, is how much is there to leave for a beneficiary and how much do you want to protect it? How much do you want to make sure that it doesn't go to someone who you wouldn't intend it to go to after they pass away? This is more the Hawaii Asset Protection Trust rules and the beneficiary deemed owner trust.
All right. So now that we went through all the black and white stuff, I think what I like about talking with smart professionals is you guys see a whole bunch of stuff and you guys aren't just dummy trust writers, right? There's some sort of learning and like seeing best practices and being able to apply certain situations, a common thing that we see from our clients. Again, between that $1 to $10 million range is that there's a certain point where I would say maybe under a few $1 million and you got 2 or 3 kids, you give $1 million to each kid. Yeah, go buy a Ferrari, whatever, have a nice life. But it's not substantial life changing money where they can grow it. Whereas if you have enough money to give your kid 4 or 5 million plus, or let's call it 10 million, some people have the idea of keeping it all into a dynasty business where the kids have to work together and roll the damn thing.
Yeah.
Maybe talk us a little bit between those two mindsets, right? Like obviously more times than not, they'll just be quarreling between the two heirs and they'll just hate each other and blow the money anyway. Unless you keep that source of money together. If you only have 10, $20 million, you need to keep that critical mass together. Maybe you can,
Right.
yeah,
So what you're bringing up here is, it's another really good point, Lane. You see this, if any of you have heard this statement, shirt sleeves to shirt sleeves in 3 generations, right? The idea there is that the generation that builds the wealth, let's say Grandpa Rockefeller creates a wealth. They pass it down to their children who grew up with a very frugal, hardworking, successful business owner parent. And so they didn't have a lot. And they have some of those qualities of frugality. The grandkids, generally, the 3rd generation, grows up where they were given a lot by their parents who didn't get that when they were growing up. And so they're a little more spoiled maybe, or they just were protected and sheltered a little more. And when they have to take over, when the 2nd generation dies, the 3rd generation almost always will blow it on. There's nothing left by then. And we see that a lot. The exceptions are the families that pass on the values. So more so than just giving them stuff, right? Whether it's real estate or cash or stocks, it doesn't matter what it is. The successful families that build dynasties, that build generational wealth, what they're doing is bringing the children in to help run the family business, bringing the children in to help manage the investment portfolio or learn about finances, and then having them also teach the grandchildren. And maybe some of them too will just say, let's incentivize them, right? For whatever you earn, you can get bonuses from the trust or whatever, versus just here's a handout. So you're disincentivized to work, right? The grandkid that's going to get a $5,000 a month handout for the rest of their life is like, I don't need to study. I don't need to go to school. There's problems with that. The most successful families will work now, not just on structuring their estate plan to pass the assets on, but how do I pass the values on, the work ethic, the knowledge? And that's, I think, an important part of your work, Lane, where you have this pool of knowledge that you're sharing with people and they can try to bring that for their families as well, to teach their kids and grandkids how to build and maintain wealth.
yeah. But I didn't learn this at MidPack. Although if MidPack wants to bring me back and me teach a course on financial literacy, reach out to our folks. Like I think college and academic gets you to a certain point, gets you on a playing field with other people. Then you can start to play ball, but that's another conversation for another day.
Yeah.
But yeah, there's kind of 2 thoughts of it, right? Some people are just tired after some point and they had a good life. They're going to give their kids a couple mil each, and they don't really need them to carry on this dynasty or whatever. And they just don't want the kids to fight over the bigger pile of money and just split the damn thing. I see this so much where there's a family house that's like that's like a recipe for disaster, right? Like you have a family house that's not liquidated and you have 3 kids fighting each other for it. And luckily, hopefully one of them isn't on drugs.
That's the beauty of having a generation skipping trust. One that continues on is you could have whoever the trustee is, could be one of the kids you trust the most, make the decision about whether to sell the asset or not, or just give a third of it out to each trust for each beneficiary. You could even have one person be the trustee for all the trusts for the kids. So there's a lot of flexibility in how you do it to prevent the fighting and either preserve the asset or not. But like you said, sometimes it just makes sense to let them choose to buy each other out or sell it, and they each get their share of the cash, and they can have that cash in a continuing trust that's protected from their divorces, etc. But they don't have to deal with their siblings anymore.
I had Bill Perkins on the podcast last month, the guy who wrote Die with Zero. It
Great.
changed my thinking a little bit, as opposed to going after like these high numbers and have them take on the family portfolio, family office,
Yeah.
family with some cool like Ethan Okura like flower symbol stamp on paper with wax. Like I was just they're gonna mess it up anyway. If I give them $1 million or $100, that's gonna be more than what most people have. And why stress out about it is my philosophy now, but it'll change 10 times from now, next 20 years.
I'm sure. Yeah.
But yeah, why don't you give your contact information, Ethan, if people want to get a hold of you here in Hawaii, but I think you can still provide referrals out to the mainland folks too, right? Or help out some of those guys.
Yeah, depending on their situation, if they need help with estate tax planning or sophisticated income tax, capital gains tax advice, we can help with anything that's federal tax law. If it's probate or something on the mainland, like in California, we wouldn't do it. We're not licensed there. But for anyone in Hawaii, we can definitely help. And we have referrals to attorneys in other states that hopefully can help if you need, but or we can work together with them to implement a sophisticated plan if you have a local attorney that has done your basic trust or your basic estate plan. You can reach us here. Our main office number would be 808-593-85 on Oahu. And there's also numbers for Hilo and Kauai offices. And the main thing to find our information would be okuralaw.com. And actually, we don't even use the www anymore. It's just https:/. So I got to update that. But
Yeah.
okuralaw.com.
But we are stepping up in the world in Hawaii. You have to put 808 now in the number here.
That's right. And the
I
area
know.
code could be in the dial. Yeah.
Yeah. We are getting into the 21st century out here. But yeah, thanks for jumping on, Ethan. And yeah, thanks everybody for listening. We'll put this in the new website, thewealthelevator.com/legal. But thanks for listening, everybody. See you guys later.